Hi there, and thank you very much for joining us today. My name is Lindsay Gibson, and I'm the Regional Director for Southwestern Ontario at Benefits by Design. If you have any questions during the presentation, please enter it into the Q&A window. The presenter will address as many questions as time permits at the end of the webinar. I'm very excited to introduce George Vassos, who will be sharing important information on employment law and what it means for working Canadians. I had the privilege of seeing George speak at a CGIB, Canadian Group Insurance Broker Seminar earlier this year. I was amazed at the amount of very valuable information shared on employment law and how it relates to group benefits. He covered everything from mistakes in regular practice when issues arise to terminating employees on leave. I hope that all participating in today's webinar are able to take away as much as I did from hearing George speak. The topics he will cover today affect all of us. George is a partner at Littler LLP. His biography is quite extensive. You can visit littler.com for more information. George's biggest claim to fame was that he was born on October 16, 1954, the day that Hurricane Hazel battered Toronto. He also comes from a family of 6 children. Without further ado, let me welcome George.
Lindsay, thanks so much for that introduction. It's a pleasure to be with everyone today on this webinar. We're going to cover a lot of territory, so buckle up your seatbelt and get ready for the ride. I am an employment lawyer by background, and in that regard, the first thing I'm going to do is give us a quick overview of the legal framework relative to employer obligations that we're going to be discussing today. And that legal framework involves Supreme Court of Canada cases where our highest court has commented on employee-employer relationships. We're going to take a look at some specific case law dealing with benefits during the employment life cycle. We're going to be talking about minimum employment standards legislation and how that impacts on benefits. And we're also going to be talking about case law from the courts known as common law dealing with wrongful dismissal and severance and termination issues. So starting first with the Supreme Court of Canada cases, in the Slate communication decision, the court talked about how it's important to protect employees as a vulnerable group in society. The court also commented on how most of us get our significant self-respect and self-esteem from the work that we do on a regular basis. And that at the end of the day, labor is not to be viewed as a commodity, and the right to work has the status of a human right. In another Supreme Court case, the public service decision, the court made comments around how important and essential work is to a person's self-worth, emotional well-being, and sense of identity, and the fact that work is one of the most fundamental aspects of a person's life. And finally, in the Wallace decision, the Supreme Court commented on how employment contracts have many characteristics that make them different than ordinary commercial contracts. And one of those characteristics is that there's a significant inequality of bargaining power as between the employer and employee. And that power imbalance pervades itself not only in the employment contract, but throughout the employment relationship. So what is the net impact of these Supreme Court of Canada decisions? Well, essentially, whether we're talking about a court or an arbitration or a labor board matter, wherever decisions are being made with respect to employment, these Supreme Court of Canada decisions essentially give employees a bit of a leg up even before the case starts. And it's through the prism of these Supreme Court of Canada cases that decision makers are looking at employment matters. Now we're going to start talking about benefit issues during the employment life cycle, and I'm going to talk about 2 or 3 cases now dealing with some issues on life insurance arising at the commencement of the employment relationship. And just before we get into those cases, I want to comment briefly on employment contracts, employment agreements. And in that regard, if you take away nothing else from this webinar, the most important message from today's webinar is the importance of employment contracts and hiring letters in that regard in an attempt to deal with benefits issues right from the outset before they become a headache during the relationship or upon termination of the relationship. We can certainly have an employment agreement that's completely oral, but in most cases we end up with employment agreements that are partly written, partly oral. The written part often shows up in a hiring letter. It sometimes shows up in a formal contract. We also have written terms and conditions that end up in company policies, but these policies have to form part and parcel of the employment agreement. If the policies are never brought to the attention of the employee, then we're hard-pressed to say they're part of the employment contract. And as part of the employment agreement between the parties, there's also a review of the course of conduct of the parties and what have they been doing over time in relation to their relationship. So the first case dealing with a life insurance issue is the Perlet Estate matter. It involved a unionized employee who passed away. On enrollment under the plan, the employee was unaware that there was a choice as between basic life insurance or insurance for twice annual earnings. So all the employee knew was that she could pick up basic life at a small cost of 13 cents per month, and the employer was picking up the rest of the cost. She didn't know about the twice annual earnings for $1.97 per month, so she took the life insurance that she understood was available. At trial, there was no evidence around a benefits booklet being handed out to employees. An unusual aspect in this case was the HR manager conceded that there was a duty on the employer to advise with respect to details of the group insurance. There was a collective agreement in this case, but there were no details in the collective agreement on coverage, and the only way the employee would have the information is that through anything provided by the employer. The court certainly found a duty of care, and the court required the employer in this case to competently administer the benefit plan. The court found that it did not do so. The court found that if the employee knew about the second option to pick up the higher life insurance coverage, the employee would have done so, and that resulted in an award to the estate in excess of $200,000 in that particular case. Now, in the Maple Leaf decision, we have a case in which the parents of a deceased employee were suing for negligence relative to the failure to properly put into place life insurance coverage. There was a 90-day waiting period in this case before eligibility for benefits, followed by a 31-day window for application. The employee didn't apply during that period. After the 31 days, there had to be evidence of insurability. And in this particular case, the employee finally completed the enrollment form 3 months late and then unfortunately died the next day. There was a booklet in this particular case that described benefits and had instructions and so on. The court found that there was a general duty of care by the employer to the employee, and where the employer administers the benefits, the duty of care applies to that administration. The court found it was reasonably foreseeable that if the employer was careless, that in turn would injure the employee. The court at the end of the day found that in this case, the employee was not provided with sufficient information to properly deal with the benefits issue, was not given important information about critical deadlines and so on, and therefore the employer didn't meet the appropriate standard of care. Having found negligence on the employer, the court didn't stop there, but then went on to look at the activities and conduct of the employee, and at the end of the day found a 50-50 split. So the employer was liable 50%, the employee was liable 50%, because the employee didn't take any of these steps. Never asked what benefits were being offered, never asked about deadlines, never asked about who to speak to, didn't reach out to fellow employees or the office manager to secure information, and didn't follow up on the information on the booklet. So at the end of the day, it was a 50-50 split on the liability. In the Barclay decision, we have an employee who goes off ill, is given a record of employment for EI sick benefits, but dies while being away from the workplace. The employer did, in this case, continue to pay disability coverage for 3 months, but inexplicably told the insurer that the employee was no longer involved, and ultimately the benefits were cut off, including the life insurance. The court held that the employer had a duty to investigate the employee's status before cutting her off benefits, and as a result of doing so, the employer was liable for canceling the group life insurance. Now we're going to start looking at some of the benefit issues during employment, and this gets us to the very important concept of frustration of the employment contract. Before we deal with the employment contract specifically, frustration generally involves a scenario where we have a critical supervening event that's not really in the contemplation of the parties. There's no fault on either party with respect to this event that's happened, and the event renders the parties incapable of performing their contractual obligations. So in a commercial context, for example, if there's a contract to produce widgets out of a factory and the factory burns down, that's frustration because the factory is no longer operative and the contract cannot be honored. In the employment context, frustration of employment ends up arising where we have significant illness or disability. And in these cases, the onus is on the employer to prove frustration. And the finding of frustration is always fact-specific depending on the particular factors that are relevant in a specific case. The first thing that our decision makers look at is what are the terms of the employment contract? What does it say about sick pay or disability benefits? Decision makers then go on to look at a whole host of other factors, including how long the employment's likely to last if there was no disability, what's the specific nature of the employment, how long has the employee been employed there, what's the nature of the disability, has there been a permanent replacement required, and finally the most important factor that comes into play in these cases, what's the specific medical evidence and what's the likelihood of recovery of this particular employee to come back to the workplace. The Supreme Court of Canada in the Hydro-Quebec case told us that we get to frustration when an employee is no longer able to fulfill the basic functions associated with a particular job for the foreseeable future. So that's the test legally. The implementation of the test is a bit harder to deal with in the real world. If you look at this slide, you can see the range of cases out there in terms of findings where there's no frustration. So you look at the case at the low end of the scale, 10 months, all the way up to 5 years. And in all of these cases, there was a finding that based on the specific facts of the case, frustration had not been proven by the employer. In the Nacarado case in particular, the employee had been away for 5 years on disability, and the doctor had written in this particular case saying, look, I really can't predict when the employee might be able to return. The doctor wasn't optimistic, but the doctor really didn't give any opinion about future attendance. And notwithstanding a 5-year disability, because the employer failed to lead medical evidence as to whether the employee could or couldn't return to work in the foreseeable future, the court found that there was no frustration. Interestingly, in this case, the benefits were cut off along the way, the other benefits other than LTD, but that somehow was not an issue in that particular case. On the flip side of the coin, we have cases in which frustration is found, depending again on the specific facts, and the range here is from a low of 8 months all the way up to 3.5 months. And again, just showing us that these cases are very fact-specific and boil down to what's the medical evidence in the particular case. We have the Nickel decision in the Court of Appeal in Ontario here, where the court said, look, if LTD coverage is provided, it may be that it's harder for an employer to get to a frustration finding. The fact that there's LTD or sick leave really tends to confirm that long-term illness is not unforeseen by the parties, and it's harder to get to that frustration finding. And with the presence of LTD coverage, there's greater tolerance for a lengthy absence before frustration might be found by a court. So why is frustration important? Well, in essence, it's important because it allows an employer to terminate the employment relationship, to discontinue benefits other than any requirements for a minimum period, and to end the relationship not on the basis of common law severance, but on the basis of statutory severance, which will vary from province to province. With respect to an employer's obligations on frustration, we really need to look at this from three perspectives. The first one is common law. So at common law, there is no obligation on an employer unless that arises via the employment contract. Under statute, the employer's obligations are dependent on what the Employment Standards Act has to say in the particular province with respect to minimum termination and or severance pay. And finally, an employer has obligations in the human rights arena, and this relates to the duty to accommodate an employee who's off on disability. And just dealing with the human rights aspect for a moment, I think everyone's familiar with the fact that we have human rights legislation across the country which prohibits discrimination on various grounds, including disability. So if we have an employer that dismisses an employee because the employee is disabled, we automatically have a potential discrimination human rights violation. If an employer dismisses an employee for several reasons, but one of those reasons relates to disability, we still have a discrimination problem under human rights legislation. And the only basis upon which an employer might be able to dismiss an employee for disability is if we actually get to the point of frustration, and it's difficult to get to that point. So under human rights legislation, before we can ever get to frustration, an employer has to look at the duty to accommodate, and that has to recognize the individual requirements of the employee, the restrictions of the employee, and how the employer can accommodate that employee in the workplace. There can never be a frustration decision by an employer acting in good faith if the duty to accommodate has not been addressed. It has to be addressed first before we get to frustration. In the Riva Plumbing case, we had an employee who was off sick with serious illness. The employer decided to treat this as a resignation. The court said, no, it's not a resignation, but the employer discontinued the benefits. So the employee decided to go to court. The employee was not looking for damages, but was looking for a declaration from the court that the employee was still covered by the benefits plan. And the court had no trouble granting that order that the employee should still be covered by benefits. But interestingly, in the case, the court didn't put a time limit on it, and there's no subsequent decision dealing with these parties. Now, one of the issues that sometimes comes up during employment with respect to benefit issues is the question of premiums. And in the Simcoe decision, we had a scenario where the employer paid 100% of the premiums for benefits for active employees, but did not pay the premiums for benefit coverage for employees who were on LTD. So the employer treated the LTD employees differently than active employees, and the issue was whether or not this was a violation of the collective agreement. The arbitrator in this case, it was a unionized scenario. The arbitrator decided that there was nothing in the collective agreement confirming that insured benefits would be terminated when the employee went off on LTD, and that benefits were a part of total comp. The parties could have addressed this in the collective agreement, but decided not to do so. And at the end of the day, the employer violated the collective agreement by not paying the premium cost of the employee's benefits. And this case highlights the importance of having clear contracts dealing with these types of issues, whether we're talking about a collective agreement in a unionized setting or an employment agreement in a non-union setting. Now, another issue that arises during employment comes in the context of workers' compensation. The Stagg decision at the Human Rights Tribunal in Ontario is a case where the employee was essentially punished by the employer because of an absence due to a workplace injury and because the employee kept requesting accommodation of the employer. And important to note from this case, the tribunal was very critical because the employer was either not responding to the employee's requests about benefits or giving information that was either delayed or incorrect. And at the end of the day, the tribunal in this case awarded $15,000 because of discrimination on the basis of disability. Now, here in Ontario, we do have legislation, the workers' comp legislation, which requires that during the first year of a workers' comp absence, the employer has to continue to make the contributions to employee benefits, the cost of those benefits, as long as the worker continues to pay his or her share as well. If the employer doesn't make those contributions, the employer is not only liable to a penalty through workers' comp, the employer is also liable for any loss that the worker suffers. So to take a simple example, if the worker's off on workers' comp and dies, then the employer may well be liable for the loss of the life insurance if the life insurance coverage wasn't continued during that workers' comp leave of absence. Now, if we've got workers' comp legislation, and whether it's 1 year in Ontario or some other period in other provinces, the question comes up, can an employer safely discontinue benefits after the 1 year for someone on workers' comp? And the short answer to that is no, because you also have to look at other terms and conditions of employment, whether they show up in a letter, a contract, in a policy. You have to look at the entire scenario before terminating benefits. And that takes us to the question of cutting off benefits for disabled employees. And this is a particularly thorny area. We have lots of employees who are off on LTD who have their health and dental coverage that continues while they're off on LTD, and indeed perhaps other benefits as well. But this varies employer to employer and insurer to insurer. Sometimes we have benefits that are continued for shorter periods of time, sometimes for longer periods of time. And the question that comes up is whether or not there's a standard that's used as a starting point as to how long an employer should continue benefits or is obligated to continue benefits when someone is off on LTD. And the short answer is that unless we get to the point of frustration, the obligation on the employer is to continue those benefits. But what employers need to look at, and benefits providers need to give some consideration to, is whether or not there's an appropriate time frame after which it makes sense to for an employer to stop paying premiums for the other benefits and for the benefits to stop. Now, I've put up on the screen 30 months with a question mark. This is not a recommendation or legal advice because it always comes back to specific cases, but this is a focal point. And the way I get to this focal point is because of a common scenario where for many companies that have STD and LTD, the STD continues for 6 months and then the LTD continues under the own occupation umbrella for 2 years before we get to the any occupation period after 2 years. So I take the 6 month STD and the first 2 years of the LTD. That's how I come up with 30 months. So that's a focal point in terms of what might end up in a contract in terms of a cutoff point for benefits. But even with that cutoff point, we still have to consider the impact of frustration along the way. We need to consider the question mark around consent from the insurer. And we need to worry about clarity in contracts, whether it's collective agreements or individual employment agreements. If we're going to have a period like 30 months for a cutoff, then it's important to provide proper advance notice at every opportunity. So when there's an STD application, remind employees of that cutoff point. LTD application, remind employees. And this can certainly come up along the way when anytime benefits are being discussed. After 30 months, the question mark comes up as to whether benefits should be cut off altogether or whether an employee might be able to pay the premium after 30 months to continue coverage. The last bullet point on this screen, employees already on LTD, no contract, no policy, no previous notice. I have a client who recently came to us who had 12 employees off on LTD, still receiving benefit coverage for other benefits, and had been receiving that coverage anywhere from 5 to 15 years, and nobody had been paying attention. Those are the most difficult cases because somehow we have to get to frustration before we can cut those people off of those benefits. Now, with that background, we get to some tips in this particular area. And the first tip is, anytime we have a disabled employee, a red flag should go up for all concerned. If we also have a disabled employee for whom we want to cut off benefits, a second red flag should go up. So the message here for you loud and clear is, if we've got a disabled employee, there really needs to be some sensitivity. There really needs to be some thought put into the scenario, because this can be a real minefield for anyone trying to deal with potential issues. And certainly no benefits should be cut off for any disabled employee unless someone knowledgeable on these issues, whether it's an HR person or an employment lawyer, has had a review of the scenario and identified significant risks and how to address the risks, whether they arise at common law, human rights, or under employment standards. In terms of any decision made to terminate or change benefits, there always has to be a focus on what are the terms and conditions of employment. That takes us back to our ongoing theme around employment contracts, hiring letters, what's in those letters, what's in those contracts, what's in the policies. If there's workers' compensation, we need to be mindful of what the statutory rules are. We also have to take a look at how we treat other employees with respect to benefits, not just the person off on LTD. If we have no contractual terms dealing with ending benefits or changing them, then there has to be a strong focus on frustration and whether or not the frustration position is sound. And obviously there has to be some consideration in more complicated cases as to whether or not to take on legal advice. Another issue that comes up around benefits during employment is the question of statutory leaves. And in this regard, we're seeing more and more leaves. And a question that comes up very often is, what's an employer's obligation with respect to continuing benefits during a pregnancy leave or indeed other leaves that are being imposed by governments? And there's a very strong trend right now on a provincial basis and on a federal basis across the country, not only to be introducing new statutory leaves, but also to increasing the amount of time for existing statutory leaves. This obviously puts workers out of the workplace more often because of the number of leaves and creates significant pressure on employers to deal with replacement employees and to deal with benefits and benefit issues while the employees are away from the workplace. Now, if you take a look at this first chart, this happens to be the current status here in Ontario with respect to statutory leaves. And I've got a second chart in a moment dealing with more of these leaves. But as you start scanning these leaves, take a look at the number of weeks where an employee, presuming they qualify, will be able to take a leave. And at the end of the leave, will have a statutory right to return to the workplace, presuming the job hasn't disappeared in the meantime. So statutory right to return to work, number one, and number two, a statutory right for benefits to be continued during these leave periods. And on this second slide, you see the current rules in Ontario cap out at 104 weeks, which is obviously 2 years, for leave related to a crime-related child death scenario. Obviously a very tragic situation, but in that type of a case, an employee would be entitled to be off on leave for up to 104 weeks dealing with those types of issues. Now, we have something here in Ontario called Bill 148. Bill 148 involves a very, very significant 2-year review of employment standards legislation here in Ontario and labor relations legislation as well. As we speak, Bill 148 is actually slated for a third reading in the Ontario legislature today. We don't expect it's going to have any problem in passing third reading. And on the heels of third reading, it will obtain royal assent. That could come today. If it doesn't come today, it will follow in very short order. And once royal assent has been granted, Bill 148 will be the law of Ontario. And as you see from this chart, Bill 148 is going to have the impact of increasing some of the statutory leaves in Ontario and introducing new leaves. So by way of a new leave, for example, the last one, death of a child, that's one of the new statutory leaves in Ontario, and effective January 1 for all of these leaves, death of a child will mandate a leave up to 104 weeks, and you see the increases on the other leaves all coming on January 1 as well. Now, built right into the statute is the requirement around the employee continuing to participate in all of the benefit plans. And benefit plans are very broadly defined under the statute. And they include not only pension plans, but also accidental death plans, life insurance, dental plans, extended health. So it's very, very broad in terms of how benefit plans are defined under Ontario legislation. And under the legislation, we have a requirement that the employer has to continue to make the contributions that the employer is regularly required to make to ensure that those benefits are in place. Now, that takes us to another issue during employment, and this involves removing or changing benefits. And this gets us to the question of how easy is it to remove or change benefits? And the simple answer is, look, on a practical level, obviously an employer can do anything, but once an employer removes or changes benefits, it certainly raises legal issues. And the legal issue of central concern is constructive dismissal. And constructive dismissal is essentially a unilateral and substantial change in fundamental terms and conditions of employment. So that can certainly include changes in benefits. And when we have a constructive dismissal, typically a court finding that employer no longer intends to be bound by the employment contract. So if the employee has not accepted the change, then the door is open for the employee to pursue a constructive dismissal position. And in that regard, constructive dismissal gives an employee the same entitlement to severance and pay in lieu of notice that an ordinary termination would. There's no difference between the two. The same entitlements arise at the end of the day. Now, as to whether or not loss of benefits constitutes a constructive dismissal really depends on the circumstances of the case. So, for example, we see this judge decision. In that particular case, the employee's salary was $25,000, so it was at a lower level rather than a higher level. And because the salary was at that level, the benefits took on greater significance. And in that particular case, the court found that there was a constructive dismissal because the benefits were taken away. Where we have benefits representing a significant portion of total compensation, it's more likely than not a constructive dismissal will be found if an employer takes those benefits away. Sometimes we have benefits being taken away, and at the same time, other changes are happening So the general rule is the greater the change to terms and conditions of employment, the more likely a constructive dismissal finding will be made by the court. And looking at these three cases briefly, the Pool and Husky Oil decision out of BC and Saskatchewan, in those two cases, the same thing happened. Certain benefits were canceled and a company car was taken away, and the court had no trouble finding constructive dismissal in those cases. In the Leversage case, a pension plan was taken away, and again, no trouble finding constructive dismissal. In contrast, in the Auto decision, in this particular case, the company reduced vacation from 6 weeks to 4 weeks and stopped the 5% contribution to the group RSP. And this was done in a context where this particular company had made periodic adjustments in benefits and perks along the way. So this wasn't the first time this had happened. There was some history of this. The court found that there was no constructive dismissal, but still went on, and if there's no constructive dismissal, there's no entitlement to severance, but still went on to find a breach of contract in this case and a relatively minor breach that attracted some damages but did not attract a constructive dismissal finding. So by way of overview in the constructive dismissal area, again, this is a very fact-specific exercise. The greater the monetary loss to the employee, the more likely we have a constructive dismissal. And we can have shades of gray. Obviously taking a benefits plan away entirely is different than taking away one element of a benefits plan. If you're only taking away one element, less likely there's going to be a finding of constructive dismissal. Now, if we're talking about removing or changing benefits, it's very, very important to think about how much notice can be provided. The more notice that can be provided of these changes, the less likely there's going to be a finding of constructive dismissal, and the less likely we're going to have fallout on a practical level. Obviously, it's important to try and keep employees happy, and the more notice we can give of changes, the better off an employer will be. And that's something that absolutely needs to be considered, along with the question of whether or not a gradual removal makes sense. Is it better if we're going to make changes to make them all at once, or is it better to try and stretch things out? Well, as a general proposition, it's better to try and stretch things out. But again, it depends on all the facts of a particular case. Back to our central theme, promoting the use of employment agreements and hiring letters. If you put this in your hiring letter at the outset, an employer then is able to take away benefits or change benefits because it's part and parcel of the terms and conditions on hiring. So I can't overemphasize enough the use of hiring letters and employment agreements. There is a secondary focus on policies, but it's certainly better to deal with this in a hiring letter than it is in a policy. Preferably you deal with it in both places, but sometimes policies are simply paper policies sitting in a handbook on a shelf somewhere and don't come to employees' attention, and that's a problem. Obviously, there's extra scrutiny if there's a collective agreement involved because the terms of that collective agreement are very important. And anytime we have information or training sessions, it's important to emphasize with employees that an employer does have the right to terminate or change benefits. Now, let's talk about benefit issues on termination. And in this regard, the issues arise under statute and at common law cases in the courts. Under statute, you see here in Ontario what the minimum entitlements are on a termination, and these minimum entitlements cap out at 8 weeks after 8 years. Similarly, in other provinces, these rules vary a little bit, but they're fairly similar to what happens in Ontario. And when we have this minimum period of termination notice or pay in lieu, the employer has an obligation during that minimum period to continue making benefit plan contributions to ensure benefits for a minimum period so the employee has time to go out in the marketplace and look for other benefits. The Supreme Court of Canada has told us that not only is an employee entitled to salary and benefits as agreed during the employment relationship, the employee is also entitled to both salary and all benefits during the period of reasonable notice applicable to termination of employment. And in that regard, when we have termination of employment, unless we have a contract that tells us otherwise, the employee has a common law entitlement. And you see from these cases that I've put up on this particular slide, these entitlements to a severance package can be very, very significant, including the case at the top of the list where the court awarded, in effect, 3 years as a severance package. So in that particular case, the employee had an entitlement to total compensation for 3 years, including benefits for that 3-year period. So these obligations on an employer can be very, very significant because of the common law entitlement. One of the most significant issues arising on termination is the question of LTD benefits. And I think all of you, if not all of you, certainly most of you on the webinar know that there aren't insurance companies that will continue LTD benefits after the statutory period. So in Ontario, if 8 weeks is applicable, once we get to 8 weeks, there's no more LTD coverage post-termination. And that raises these issues for employers. So in the Canac Kitchens case, the employer in that case provided 8 weeks of benefits, gave the employee their statutory entitlement to termination pay and severance pay, but did not replace disability coverage after the 8 weeks. The employee became seriously ill after termination about 16 months down the road. The employee was age 55 when he became disabled. And very importantly in this case, the court found that the common law notice period that Canac Kitchens was required to give was 22 months. And because the employee became disabled at 16 months post-termination, that was within the 22-month period. The employer did not continue disability benefits. Therefore, the employer stepped into the shoes of the insurer and was liable for the disability benefits for 10 years from age 55 to 65 as if the employer were the LTD insurer. Total damages in that case in excess of $200,000. Now in a BC case, the Prince decision, the LTD liability here was even greater than in the Ontario case. And in this particular case, the court found that the reasonable notice period was 42 weeks. The employee became disabled within the 42 weeks, was age 41 at the time of disability. And the trial court in this case granted a declaration that the employer was liable for the LTD because that insurance coverage was not continued. So what did that mean on a practical level? Well, because the employee was age 41, this employer was liable for 24 years of LTD coverage. Now, not surprisingly, the employer didn't like that decision, so they appealed to the Court of Appeal. The Court of Appeal agreed with this decision for 24 years, but said that the trial court erred in one respect, and that is the trial court did not consider contingencies. So, for example, the trial court did not consider what's the likelihood that this person might die before age 65 and not receive LTD benefits till age 65. So the Court of Appeal sent it back to the trial court to deal with that issue. There is no further court decision reported, so we don't know what the ultimate outcome was in that regard. Now, in the Allied Chemical case, this was also an LTD case. And in this particular case, the employee passed away post-termination. The widow sued for LTD. But both before and after the employment, the employee suffered significant issues with depression, paranoid thinking, and mood swings, and this led to very visible behavioral issues in the workplace. And at one point, the employee wrote a letter of resignation. It was accepted. He left work. He got progressively worse with delusions. And it was 1 year later that the employee wrote a letter back to the employer confirming these serious health issues. The court in this case found that there was a duty of care owed by the employer to the employee even though this letter from the employee did not come until 1 year later. And the employer should have contemplated that if they were careless, this likely would cause damages to the employee. In this particular case, the obligation on the employer, according to the court, was to assist the employee in completing the required forms for the LTD. The basis for liability in this case was not that the employee was disabled during the notice period after termination, but that the employer really should have realized that there were serious medical issues and that the employee was really disabled while still a full-time employee. Now, there happened to be joint liability in this case between the employer and the insurer, but for our purposes, we don't need to delve into those issues. Now, on termination, certainly life insurance issues can arise. In the Robertson Mechanical case, we have a scenario with significant medical issues and ongoing family issues. The employee was advised to take a 3-month leave of absence. The employee was given no choice about the leave, and he thought he was fired. The employer in this case really knew that the serious medical issues and personal problems created a great vulnerability for the employee. The employer also knew it was very important for the employee to maintain group coverage, but didn't ask the insurer about the impact of the 3-month leave of absence in this case. And the employer, for whatever reason, decided to terminate the employee from the group insurance plan. That meant that the group life dropped off in terms of coverage. The employee happened to die 11 months after the constructive dismissal, and then it came time for the court to decide, well, what's the period of reasonable notice in this case? And lo and behold, the court decided that reasonable notice was 12 months. The employee died after 11 months, and because the employee died during the reasonable notice period and the employer did not continue the life insurance, the employer was on the hook for the life insurance, $50,000 in this particular case. This is a good example of hearkening back to the Supreme Court of Canada cases where the Supreme Court tells us employees are vulnerable, courts need to protect them. Not a surprise to me that the reasonable notice period was 12 months in this case, allowing the employee to recover those damages. Now, benefit issues, how do we limit or reduce liability with respect to these issues? So these are now some practical considerations, and this is the type of advice that we get into with employers dealing with benefits and the mishandling of benefits or the discontinuation of benefits. It's really a very significant area of potential liability for employers, but this liability can certainly be managed if some thought is given to appropriate steps to be dealing with these issues. So let's start in this regard with some simple practical considerations. And the first practical consideration is to know, for an employer, to know what they actually have by way of coverage under the group insurance policy. The simple proposition is that the employer should not be offering on termination coverage that is not being supplied by the insurer. So it's very important for an employer to be contacting the broker and or the insurer prior to terminating an employee to know what that coverage is and to be having a conversation with respect to what coverage will extend beyond the statutory notice period. Now, I've been at this for a good many years, and I can tell you my experience briefly is as follows, that there's no disability insurer, again, that continues disability, group disability beyond the statutory period. My experience with life insurance, I'd say probably 75% of the time it'll be continued. If the premiums are paid, 25% of the time it's not continued. And other benefits, health and dental, generally speaking, there's no problem there. Premiums are paid, that coverage will continue. AD&D, I'd say probably a 50-50 scenario in terms of coverage or not. in terms of what I'm seeing. So the employer's got to have a conversation to know what can be continued and can't be continued. And it's surprising to me how many employers don't have that conversation or don't know already what the coverage is, and then make promises in termination letters that they really can't cover off. And an obvious one being telling an employee that all benefits will be continued during the notice period when the insurer will not back that. Transitional disability insurance. I know there's some of that in the marketplace. It usually takes some hunting down to find it. But if we have an employer who has an employee who has had significant health issues, one way for an employer to eliminate or reduce liability is to consider whether or not to pay the cost of transitional disability insurance on an individual basis to replace what the employee had on a group basis. So this is particularly important where there has been a history of medical issues, because certainly the employee is going to be looking at this very carefully and raising this as an issue as part of a severance negotiation. The full and final release. The simple proposition here is if you pay enough money in a severance package, you'll ultimately get the full and final release, and the full and final release and the terms of the settlement agreement will cover off the benefit issues. So one of the terms of the settlement agreement, for example, will be there's no disability coverage beyond the 8 weeks. So you build in those terms and conditions, you link that with the full and final release, and that should get an employer to a comfortable place where this will cover off benefit issues. But if we have an employee, for example, with significant medical issues, it may be that you have to pay a greater price on the severance package in order to get a deal and in order to get the full and final release signed off. Another consideration for an employer is with respect to working notice. My experience is that 95% of the time, there is no working notice. Now, it's important to note that the technical legal obligation at common law is that an employer should be giving working notice. An employer should be giving notice of termination. And whether that's 6 months down the road, a year down the road, that is the technical legal obligation. 95% of the time, the employer breaches that obligation. 95% of the time, it's an immediate termination of employment, whether it's with cause, without cause. Generally speaking, the employer doesn't want the employee to continue in employment for many reasons: confidentiality issues, not wanting the employee to be disgruntled and impact customers negatively, and so on. So there's certainly disadvantages to working notice on a business level and a practical level. 5% of the time, there is working notice. And if we have that working notice, it generally means status quo. The salary continues, the commission plan continues, the benefits continue. So we shouldn't have benefits issues as long as you're picking the right number of months on the working notice. And generally speaking, in the 5% of cases where there is working notice, it generally involves senior employees and often involves employees who have professional obligations. So, for example, lawyers who have their own professional obligations, doctors, dentists, architects. So these are the 5% of cases, either senior people or professional people, where there's still a level of trust that working notice will actually be meaningful for both parties. Conversion rights, very important consideration, and certainly there is potential liability to an employer. There's actual liability on the case law if you don't advise an employee, for example, about conversion rights on life insurance. The employer knows more about the benefits than the employee does, and so the focus is on the employer, who has the greater bargaining power and the greater information, to provide proper information to the vulnerable employee who's most vulnerable at the time of termination. And this should be included either in the termination letter or in a letter shortly thereafter, confirming all of the conversion rights. So conversion of life insurance is standard. LTD coverage, I think I've seen that 2 or 3 times over the years. It's out there. The purchase of non-LTD benefits through a new group plan, we're seeing more and more of that from insurers. So if you finish coverage under your existing group plan, you can stay with the same insurer and go into other group coverage as long as you're paying the individual premium. The employer should be putting these things on the table for the employee as a means of reducing liability or potentially eliminating liability. And that finally takes me to where we started. So we've come full circle, and relative to the full circle, we're back to the written employment agreement and the hiring letter. So certainly we have oral contracts. We're seeing more and more employers making use of hiring letters. And here's the general proposition. The general proposition is for employers, an employee will sign almost anything that you put in front of them. And why will the employee do that? Because the employee wants the job. The employee is either unemployed and wants to get reemployed as quickly as possible, or the employee is not happy where they are and they'd like to leave their current job and go to another job as quickly as possible. It's a rare scenario when we've got an employee who has multiple job offers and might look at your hiring letter and say, well, I don't like your terms and conditions, so I'm going to go with the other offer because I don't have all these terms and conditions included. That's a rare scenario. So if it behooves an employer to protect itself in the hiring letter or the initial employment agreement as much as possible, and if the employee is going to sign virtually anything, that's the opportunity to set some of these ground rules. So for example, one of the ground rules you can set right from the outset is if and when the employee is terminated without cause, all the benefits will continue for the statutory notice period, but disability will drop off and others, the coverages may drop off, and maybe it's only health and dental that continues after the statutory notice period. But that's the kind of thing that you can put in the initial letter to protect the employer at the end of the process, and indeed protect the employer during the course of the employment relationship. So this is the takeaway. The biggest takeaway from my webinar today is the importance of hiring letters and written employment agreements to either reduce liability or eliminate liability for the employer. If you're a benefits broker, it's a great tip that you can give to your employer clients. And if you're a benefits broker who employs people, you can deal with it in your own business. And if you're an employer out there, this is absolutely where you want to have your focus. Now, Lindsay, that brings me to the conclusion of my remarks for today, so I'm happy to turn things back over to you.
Thank you, George. That's great. Do you have time to answer one question?
Yeah, let's answer one or two. Let's start with one and let's see how our time is, but sure, happy to get into some of the questions.
Perfect. Thanks, George. So the first question I have is, assuming that an employer has no current proof of frustration of the employment contract, what benefit issues and other issues does an employer face in terminating a disabled employee on LTD?
Okay, so this is a great question, and hearkening back to what we were talking about during our webinar, the first red flag should go up because we have a disabled employee. Second red flag should go up because we're now trying to terminate employment and terminate benefits at the same time. So let me answer this question with a real case that's out there. So there'd be a real problem in this case to terminate the employee's employment because we don't have frustration. There's a case out there called FAIR, F-A-I-R, and it's a case that went to the Human Rights Tribunal. In that particular case, the employee was disabled and was terminated, so all the benefits were cut off, terminated from employment, And what the Human Rights Tribunal found was that the employer failed to properly accommodate the employee. And given the failure to properly accommodate, given there was no frustration of contract, the employer violated human rights legislation because the basis for the termination was disability. You can't discriminate on the basis of disability. That was the reason for the termination. And the outcome of this case was horrendous to the employer. Because it's the Human Rights Tribunal has very wide discretion in terms of a remedy. And what happened in this case, the case took forever to get to a hearing. It took 8 or 9 years under our old human rights system for this case to get to a hearing. The court found against the employer, and by way of remedy, they just killed the employer because not only did they reinstate the employee to employment, the employer had to pay all the back pay and all of the benefit issues. So whatever the employee spent for benefits coverage during that period was also payable by way of damages. This employer had to reinstate the employee and pay approximately $450,000 by way of damages. So the message here becomes, if you're going to terminate a disabled employee, you don't have frustration, you haven't properly accommodated, an employer is going to pay a very, very significant price. Lindsay, I think we're now just a bit over time, so let me just reiterate. I know there's some other questions in the Q&A line here. I'd be very happy to answer those questions, so we do have your emails. And what I will do is work my way through the questions with a view to getting back to you and giving you some information that hopefully you'll find useful. So thank you very much. I appreciate your attention on the webinar. It's been a pleasure to be here with you today. Lindsay, back to you.
I agree, George. Thank you. And thank you to everyone who joined us today for the webinar. And have an incredible day. Bye, everyone.